Uh, Dear ladies and gentlemen, very good evening and Assalamu alaikum wa rahmatullahi wa barakatuh. Thank you very much for joining us in today's webinar, engaging a discussion on the 13th Amendment to the Constitution, titled Reflection on the 13th Amendment to the Constitution. So we already completed several webinars and discussion on various topics. So those recordings are available on our Facebook page, RPSL Consortium. So please, like the page and engage with us. On behalf of the Youth and Empowerment Sectoral Committee of the RPSL, I welcome all of our discussant members and the audience. It is great to see your commitment and participation today. So I feel honored and happy to moderate this important session because today I am having an opportunity to hear my respectful professor and my academic mentor, Professor A. Sarveswaran, sir. So we are so delighted to have you, sir. We hope to continue this session for 1 hour to 1.5 hours. And there will be a question and answer session at the end of the presentation. We welcome all of you to raise your questions, thoughts, or comments relevant to the topic. You can pose your questions into the chat box. And by raising your hand at the end of the presentation, you can raise your question. So before starting today's proceedings, and formally, I cordially invite Engineer Mr. Noorul Munawwara to deliver the welcome address. Engineer Noorul Munawwara is an alumni of Faculty of Engineering, University of Peradeniya. She joined Lanka Electricity Company, and in 1989, she joined the Electricity Board. She served in different positions in the CEB and retired as Additional General Manager for Corporate Strategy after 30 years of service in the engineering industry. She is also a passionate Toastmaster who led the country as District 82 Director of Toastmasters International, which is consist of 170 plus Toastmasters clubs across the island. Also brought fame to the Sri Lanka by taking the country world ranking number 6 during her tenure. So, currently he's the treasurer of the RPSL Consortium. So this is my privilege to invite you, Madam Noorul Munawwara. Over to you.
Thank you, Mr. Kamal Ahmed, for the introduction. Yes, guest speaker, Professor Sarveswaran, members of RPSL Consortium, audience from Sri Lanka and overseas. It's a special day today as we are going to learn and earn more knowledge on the current and hot topic which is spoken in Sri Lanka. I would like to welcome all of you on behalf of RPSL Consortium and listen to the esteemed speaker on this specialized subject as we need to enhance our knowledge on this special subject, especially the non-legal people. Some of you must have heard about RPSL Consortium as at now, but some might not have heard about. Just to brief about RPSL Consortium is a forum aiming to provide a platform for eminent personalities committed to serving society through collective efforts to build a peaceful and prosperous Sri Lanka where all citizens live with peace, dignity, and respect. RPSL Consortium, founded in 2018, with the objective of building bridges and promoting unity and harmony among communities, as I said earlier. RPSL Consortium has grown strength to strength with the high caliber and committed membership consisting professionals from different fields, medical, law, engineers, accountants, so many professionals, different fields and businessmen, etc. It is headed by the President Attorney at Law Shabri Halimdeen, with his dynamic leadership, along with Vice Presidents Professor Aslam and Mr. Wazir Mukhtar and Dr. Shamila Dawood, who is lecturer at Faculty of Law, University of Colombo. The organization too is fortunate to have patrons, Mr. Saif Hanifa, who is giving tremendous contribution to build RPSL Consortium and its services. Also, RPSL is governed by Board of Management and having an advisory panel separately to get advices on and off when we need. RPSL Consortium had conducted number of projects along the years, even during the pandemic situation, for betterment of society and nation at large through different sectors headed by different committee chairs. The main sectoral committees inactive are Youth Empowerment Committee, which is responsible for today's project, and Women Empowerment Committee, Interfaith and Education, etc., etc. You can always visit the website of RPSL Consortium to get further updates. Today program is organized by the Youth Empowerment Committee, which is led by Dr. Ali Ahlam Nawaz, who is another enthusiastic leader and determined to serve the society. Even if he keeps silence, he will be back. He will really ask us the progress, and he will see that every month we will have a session on the particular day. Today, we are going to be enlightened by an eminent speaker who is really very conversant in the hot topic, a reflection on the 13th Amendment to the Constitution. The speaker today is a professor at Department of Private and Comparative Law, Faculty of Law, University of Colombo, Professor Sarveswaran. He has obtained his MPhil degree in labor law from Faculty of Law, University of Colombo. Also has obtained his master's degree in international peace studies from UN mandated university in Costa Rica. He teaches labor law, environment law, and subjects in the area of conflict and peace studies for undergraduate program and postgraduate programs. He has served as the coordinator for postgraduate program in conflict and peace studies at Faculty of Graduate Studies, University of Colombo. He has received the Environment Law Champion of Asia Award from the Asian Development Bank. He is an Asia Leadership Fellow of the International House of Japan. He was the founder director of the Legal Research Unit, Faculty of Law, University of Colombo. He served as member of the experts committee appointed to draft the new constitution for Sri Lanka 2020. And the moderator for today is another expertise in law. Today is Mr. Kamal Ahmed. Kamal Ahmed is an attorney at law of Supreme Court of Sri Lanka and currently attached to the Faculty of Law, University of Colombo as a lecturer. Before joining the faculty, he worked as a legal research officer at the Court of Appeal of Sri Lanka, the second apex court in the Sri Lankan legal system. Kamal is also a member of Youth Empowerment Committee of the RPSL. So, dear audience, next 1 hour for you, it's for you to enhance and to enrich your knowledge in this particular hot topic. Mr. Kamal, over to you to proceed.
Thank you, Mr. Munawara. So for those remarks, So as you mentioned, actually, the 13th Amendment is a hot topic nowadays. And we have a very eminent and experienced resource person in the discipline of law. So Professor Sarveswaran, and why it is a hot topic in terms of the power sharing and devolution in Sri Lanka. We often quote and we often debate the topic, right, when it comes to Sri Lankan context. So without further delay, so I cordially invite Professor Sarveswaran sir to enlighten us on the topic. Sir, over to you.
Right. Thank you. Thank you. Good evening, everyone. Thank you very much for the very kind introduction. You may have some problem in hearing me because I have a small problem in my throat. But anyway, I will do my best. So when it comes to that topic today, it is much spoken topic, which is the 13th Amendment to the Constitution. Before I go into the 13th Amendment, I would like to explain what is 13th Amendment. So the 13th Amendment is basically devolution of powers. When it comes to devolution of powers, the powers have been devolved to the provincial councils. You may ask me, what is the difference between devolution of powers and power sharing? When we talk about power sharing, it comes under the federal system of governance. When it comes to the federal system of governance, we have power sharing. So when it comes, that is the fundamental difference between the two. One is devolution of powers, other one is power sharing. But the 13th Amendment is not about power sharing. It is about devolution of powers. Since we don't have much time, I don't want to go for the other differences between the two. So the 13th Amendment basically devolves powers to the provincial councils. When it comes to devolution of powers, I will give a very simple example based on our university system. When it comes to our university, if the vice chancellor of the university says that I have all the powers, I will decide what the faculties will have to offer, what the faculties will have to decide. I will decide about the curriculum of all the faculties. I will decide about the bylaws of all the faculties. I will decide how to teach the subjects in the faculty. Then the faculties will not develop. When it comes to our university system, the powers have been devolved from the top to the bottom. So the powers have been given to the faculties. From the dean of the faculty, the powers have been given to the departments. If the vice chancellor says, I have the powers, I will retain all the powers with me, then the faculties will not develop. If you want to develop the faculties, then we have to devolve the powers to the faculties, because the faculty knows what is the best to do. The dean, the staff, and the heads can decide what they have to do for the faculty. Of course, the vice chancellor and the senate and the council will have control over what the faculties decide, but the vice chancellor and the senate and the council can't decide what is needed to the faculties. The faculties will have to decide. So the powers have been devolved at the faculty level. So when the faculties develop, automatically the university develops. So devolution of power works in such a way. When it comes to devolution of powers, here the provincial councils, I would say it is very important for the reconciliation of the ethnic conflict. At the same time, it is very important for the development of the country. When it comes to the provincial councils, I would say the provincial councils should be empowered to make use of the resources at the provincial level and generate their own funds. So with that small introduction, I will go to the 13th Amendment. So when it comes to the 13th Amendment, I will put the 13th Amendment in the screen and I will explain the important things. But I know most of you are not familiar with these legal provisions. For your understanding, I will summarize after I explain the key points in the 13th Amendment. So when it comes to the 13th Amendment, there are many people speak about the 13th Amendment, but in my opinion, most of the people who speak about the 13th Amendment do not have any understanding about the 13th Amendment. They just make their comments without knowing what is in the 13th Amendment. In my opinion, the 13th Amendment has been drafted very, very carefully. So when it comes to the introduction, I would say, when you look at the 13th Amendment, you may think that the provincial councils have so much of powers. But when you analyze the provisions, you will find that the provincial councils are empty shells. And also the provincial councils are very much controlled by the central government. So we will go for the important provisions. The first one is Article 154A, paragraph 3. When it comes to this article, here it says Parliament by law can merge two or more adjoining provinces as one province and have one provincial council, one chief minister, and one board of ministers. So when it comes to this article, if you are really interested in the 13th Amendment, please note the articles. And also, when you have time, you can go to the internet and download the Constitution and look at them very carefully. So when it comes to Article 154A, paragraph 3, provides for the merger of the provinces. When it comes to the merger of the provinces, it provides Parliament by law. So when it comes to the word law, here ordinary legislation. Parliament can merge 2 or 3 adjoining provinces as one province with one provincial council, with one governor and one chief minister and one board of ministers. So you may ask me, there was a merger of the 2 provinces, North and the East, and thereafter the Supreme Court has demerged the 2 provinces. But the Supreme Court has demerged the 2 provinces on a technical ground. But the Supreme Court decision has not amended what is in Article 154A3. Still, the merger is possible. But here, it doesn't need any amendment to the Constitution. It doesn't need any referendum. The only thing is Parliament will have to merge the provinces by law, by an ordinary legislation. But the question may be whether it is possible in today's context, whether the people in the Eastern province will agree for the merger or not. But that is a political decision. I don't want to go to the political decision. I here explain what is in the 13th Amendment. Therefore, the summary is what? Still, merger is possible by an ordinary legislation. That is the summary here of the 13th Amendment. Then when it comes to Article 154B, it is about the powers of the governor. So under the 13th Amendment, the governor has more powers than the chief minister elected by the people of the province. When it comes to the governor, here it says, shall be appointed by the president. According to 154 B2, the president can appoint any person as the governor. So when it comes to that appointment, the president need not consult the chief minister. So in other words, the president can appoint anyone who may be against the wish of the chief minister of the province or the people of the province. The president has the discretion to appoint anyone as the governor. Then when it comes to the removal of the governor also, it is in 154B4. Here it says the provincial council can pass a resolution and request the president to remove the governor. The provincial council can pass a resolution based on violation of the constitution or the misconduct or the corruption by the governor and request the president to remove the governor. But here look at the wordings in 154B4. It says president address to the president advising the removal. Advising. The word advice is very important here. The word advice is not binding the president. Therefore, even though the provincial council passes the resolution, still the president can decide not to remove the governor. Not to remove the governor because of the word advice. So it is not binding the president. So the summary is the president can appoint any person as the governor, and also only the president can remove the governor. The provincial councils can pass a resolution requesting the president to remove the governor, but the president can still decide not to remove the governor. So the appointment and the removal of the governor of the province is vested with the president. Then if we go to the next important one, the governor may from time to time summon the provincial council or prorogue the provincial council. The governor may dissolve the provincial council also. But only thing here, when the governor exercises the powers under this paragraph, there should be an advice from the chief minister. There should be an advice from the chief minister. So basically the governor who is appointed by the president has more powers than the chief minister elected by the people of the province. Then we will go to the next one. Here 154C says the executive power of the provincial council shall be exercised by the governor of the province. So the executive power of the province is vested with the governor of the province. And the governor can exercise the powers directly or through the board of ministers of the province. So when it comes to the fundamental provision here is that the governor has the executive power of the province. Then when it comes to the board of ministers of the provincial council, the board of ministers include the chief minister, and the chief minister will be the head of the board of ministers and not more than 4 other ministers. So here the chief minister and the 4 other ministers are to aid and advise the governor of the province in the exercise of his functions. So basically the chief minister and the ministers of the board of ministers come under the governor of the province here. Then another important controversial provision is about the statutory powers of the provincial councils. When it comes to the provincial councils, here it says list 1 in the 9th schedule. The list 1 is the provincial council list. There are 37 subject matters in the provincial council list. So every provincial council can enact its own statutes with regard to the subjects devolved to the provincial councils. Again, 154G2 says if Parliament is going to repeal the 13th Amendment, if Parliament is going to repeal the 13th Amendment, the Parliament can repeal the 13th Amendment with 2/3 and bringing an amendment to the repeal the 13th Amendment. So here it says a bill for the amendment or repeal of the provisions of this chapter or the 9th schedule, basically to repeal the provincial council, become law unless the bill has been referred by the president and thereafter it is passed in parliament with a special majority. So here the special majority in Article 82 is the 2/3 majority. So it need not go for the referendum, but parliament can introduce an amendment with 2/3 majority and repeal the 13th amendment. So that is the fundamental difference between devolution of powers and power sharing. When it comes to the federal system of governance, the powers shared cannot be taken back. The powers shared cannot be taken back. But when it comes to the provincial council system, the India provincial council system could be abolished. The India 13th amendment could be repealed. So in that sense, the 13th amendment and the devolution of powers and the provincial council system differ from the federal system of governance. So the next important point is here when it comes to Article 154 G3. So when it comes to this article, here it says how a provincial council can pass a resolution that we have discussed. Matters in the provincial council list, parliament can pass a legislation with regard to a subject matter that has been devolved to a provincial council. I repeat again, parliament can pass a legislation with regard to a subject devolved to a provincial council, devolved to the provincial council. But here, when parliament passes a legislation, with regard to a subject matter that has been devolved to the provincial councils, the article provides two different situations. The first one is if all provincial councils agree to pass the legislation, if all provincial councils give their consent to pass the legislation, then parliament can pass the legislation with 2/3, sorry, not 2/3, simple majority. If all provincial councils give their consent, then parliament can pass the legislation with simple majority and apply the legislation in all provincial councils with regard to the subject matters already devolved to the provincial councils. That means if all provincial councils give their consent, then parliament can legislate with regard to the subject matters devolved to the provincial councils. That legislation will have to be passed with simple majority. That is situation number one. Situation number two, if one provincial council does not agree for the legislation. So here when I say the legislation by parliament with regard to a subject matter devolved to the provincial councils. When it comes to such legislation, if one provincial council, we will assume the Northern Provincial Council has not agreed for it. When it comes to that situation, again, there are two situations. If parliament passes the particular legislation with simple majority, then that particular legislation will apply to all the provincial councils which have given the consent, except the Northern Provincial Council, because the Northern Provincial Council has not given the consent to pass the particular legislation by parliament because that particular subject matter has been devolved to the provincial council. Therefore, the Northern Provincial Council has not given its consent. In that situation, if parliament passes the legislation with simple majority, it will apply within all the provinces which have given the consent except the Northern Provincial Council. Another situation, when it comes to the subject matter Northern Provincial Council has not given the consent, but all other provincial councils have given the consent, except the Northern Provincial Council. But the subject matter has been devolved to the provincial councils. But still, Parliament is going to legislate a legislation with regard to a subject matter devolved to the provincial councils. If Parliament passes the legislation with 2/3, then that legislation will apply within all provinces, including the Northern Provincial Council, which has not given the consent. In that way, the Divinaguma Act has been passed. When it comes to the Divinaguma Act, the consent of all the provincial councils have not been obtained, but since it has been passed with 2/3, it became a legislation applicable to all the provinces. So the summary of this article is Parliament can pass a legislation with regard to a subject matter devolved to the provincial councils with 2/3 majority and apply the legislation within all the provinces, including the provinces which have not given their consent. In that sense, it differs from power sharing and the federal system. When it comes to the federal system, there will be power sharing. The central government and the regional government will have the equal powers. But here, the powers of the provincial councils come under the legislature and the central government. So then I will go to the next one. So when it comes to the the next one, paragraph 5. So when it comes to paragraph 5, right, that I think we have covered that one, right? So the another situation here is if any paragraph 6. Yeah, paragraph 5, we will go for paragraph 5. Parliament may make laws with regard to the subject matters in the congruent list. So when it comes to the 13th amendment, there are 3 lists. One is the provincial council list, the other one is the central government list, the other one is the reserve list. Congruent list. Provincial council list with regard to the subject matters devolved to the provincial councils. Reserve list, the subject matters reserved with the central government. The third one is the congruent list. When it comes to the congruent list, the subject matters come between the two, central government and the provincial councils. So here it says Parliament can make a legislation with regard to a subject matter in the congruent list after the consultation with the provincial councils. But here, look at the word consultation. The word consultation is not binding, That means Parliament can simply make a legislation with regard to a subject matter that has been included in the congruent list. Then paragraph B, every provincial council may, subject to this, the constitution, make the statutes applicable to the province, right, with respect to any matter in the congruent list. So the provincial councils also can make statutes with regard to the subject matters that are in the, congruent list. Then paragraph 6. When it comes to paragraph 6, it is very important here. If any provision of any statute made by a provincial council is inconsistent with the provisions of any law made in accordance with the preceding provisions of this article, provisions of such law shall prevail and the provisions of such statute will not prevail. That means when it comes to a subject matter that is in the congruent list, if Parliament has made a legislation and a provincial council had made a statute, and if there is a conflict between the two, the legislation made by Parliament with regard to the subject matter in the congruent list will prevail. So that means the legislation made by Parliament will prevail. So I repeat again, when Parliament enacts a legislation with regard to a subject matter in the congruent list, and a provincial council also enacts its own statute with regard to the same subject matter, and if there is a conflict between the two, the legislation enacted by Parliament will prevail. Then subparagraph 8. But this one also another controversial one. Many people think because of this paragraph, Parliament can't enact a legislation which will be inconsistent with the legislation that or the statute made by a provincial council. In other words, some people who says that the full implementation of the 13th Amendment will affect the sovereignty of the state, make an argument based on this paragraph, saying that first we will look at the paragraph. It says where there is a law with respect to any matter on the provincial council list on the date the chapter comes into force, and the provincial council enacts a statute, the particular law enacted, the legislation enacted by Parliament will, the operation of the legislation will get suspended within the province. I repeat again, we will go for a situation. There is a subject matter devolved to the provincial councils. Now, a provincial council has enacted a statute. Provincial council has enacted a statute with regard to the subject matter devolved to the provincial council. Already, there is a legislation enacted by Parliament with regard to the same subject matter. Then this paragraph 8 says, if there is a conflict between the legislation enacted by Parliament and the provincial council, then the legislation enacted by Parliament will cease to operate within the provincial council. We will go for a hypothetical situation. There is a legislation already enacted by Parliament. Now, the Northern Provincial Council has enacted a statute with regard to the same subject matter, because the particular subject matter is in the Provincial Council list. Therefore, the Northern Provincial Council has enacted a statute. Now, there is a conflict between the statute enacted by the Northern Provincial Council and the legislation already enacted by Parliament. When it comes to that conflict, this paragraph 8 says the legislation enacted by Parliament will cease to operate within the Northern Provincial Council area. Then you have to look at this paragraph very carefully. When you look at this paragraph very carefully, you will find the way it is worded. Look at it very carefully. So here it says, where there is a law, right, that means a legislation already enacted by Parliament with respect to any matter on the provincial council list in force on the date on which the chapter comes into force. That means what I have explained will apply only to the legislation enacted before the 13th Amendment has been passed. So this provision will not apply for the legislation enacted by Parliament after the 13th Amendment has been passed. I repeat again, this paragraph will apply only to the legislation enacted by Parliament before the 13th Amendment has been passed. If any legislation is passed by Parliament after the 13th Amendment and there is a conflict between the legislation and the statute, then this paragraph will not apply. That means that particular legislation will apply within the provincial council area. So when it comes to that legislation, because of the previous provisions, Parliament will have to pass the particular legislation with 2/3. Then that will apply within the provincial council, even though the provincial council has enacted a statute with regard to the subject matter devolved to the provincial council. So this particular paragraph will apply when it comes to the situation where Parliament has enacted a legislation. I go to the provision again, respect to any matter on the provincial council list in force on the date on which the chapter comes. That means this provision applies when there is a legislation enacted before the 13th Amendment conflicts with a statute enacted by the Provincial Council, then only that particular legislation will cease to have operation within the Provincial Council. So the simple answer here is, even though the subject matters have been devolved to the Provincial Councils and a Provincial Council has enacted a statute, but still Parliament can pass a legislation with regard to the subject matter with 2/3 and implement the legislation passed by Parliament within the Provincial Council, including the Provincial Council, which has enacted its own statute. So then we will go to the other important provisions. Then when it comes to the Provincial Councils, they have the legislative power with regard to the subject matters devolved to the Provincial Councils. When the Provincial Councils elect the statutes will have to be ascended by the governor of the province. So the Provincial Council will have to present the statute to the governor for his assent. So when it comes to the governor, again, the governor can assent the statute or refer the statute back to the Provincial Council to reconsider the statute. The governor can make his suggestions and refer the statute back to the Provincial Council. If the governor finds there is a conflict between the constitutional provisions and the statute, can refer the statute to the president to be placed before the Supreme Court to decide the constitutional validity of the statute. So when it comes to the summary of this article, the statutes enacted by the Provincial Councils will have to get the assent from the governor appointed by the president. The statutes enacted by the Provincial Councils will not come into operation without having the assent given by the governor of the province. Now we will go to the next one about public security. Many people argue if the police powers are given to the Provincial Councils, then it will become a serious threat to national security of the country. But we will see the provisions of the 13th Amendment. Here 154J says, after the proclamation under the Public Security Ordinance, for certain reasons, for the maintenance of essential supplies, services, or threaten that the security of Sri Lanka is threatened by war or external aggression or armed rebellion, the president may give the directions to any governor. So what it says, if there is a threat to national security, if there's a threat to national security or to ensure the maintenance of essential supplies and services, the president can proclaim under the Public Security Ordinance and give the directions to the governor of the province. So after the proclamation under the Public Security Ordinance, the president can give the directions to the governor of the province. For an example, we will say the president considers that there is a threat to national security. Then president can make the proclamation under the Public Security Ordinance and give the directions to the governor. Then what the governor will have to do? The governor and the provincial councils will have to comply with the directions given by the president. I repeat again, after the proclamation under the Public Security Ordinance, the president can give the directions to the governor to ensure national security or maintenance of essential services or supplies. When the president gives the directions to the governor, then the governor and the provincial council will have to comply with the directions given by the president. If they don't comply with if the governor or the provincial council does not comply with the directions given by the president, then the president can decide that the administration of the provincial council cannot be carried out in accordance with the provisions of the constitution. Thereafter, what the president can do? Thereafter, the president considers that the affairs of the provincial council cannot be conducted according to the constitution. The president may, by proclamation, assume to himself. The president may, by proclamation, assume to himself all or any of the functions of the administration of the province. So the president can assume to himself all or any of the functions of the administration of the province vested with the authority of parliament. So the president can make the proclamation and assume the powers of the governor, and also declare that the powers of the provincial councils will be exercised by parliament. So basically, in that situation, president and parliament will take the powers of the governor and the provincial councils. So I repeat again, president can make proclamation under the public security ordinance if there is a threat to national security, and take the powers of the governor and the provincial councils. Therefore, when it comes to this article, I would say, even if devolution of police powers to the provincial councils is a debatable one, some people may argue whether we have to devolve the police powers to the provincial councils, since Sri Lanka is a small country. That you can is police powers will become threat to national security or not. There are some more provisions. After that, I will come back to this. But here the summary is, after making a proclamation under the public security ordinance, the president can take the powers of the governor and the provincial councils, and the president will exercise the powers of the governor, and parliament will important provisions. I think we have to focus, and also by the 13th amendment, the provincial high courts have been established. So now I think we will go for the two controversial issues. One is the land powers, the other one is the police powers. So when it comes to the police powers and the land powers, I will again go to the provisions here, page 184. Those who are interested in, please note the articles and note and look at them very carefully, because the way the 13th amendment has been drafted is very difficult to be understood by an ordinary person, a layman. And also the 13th amendment has been drafted in the manner, on its appearance, you may think the provincial councils have many powers, but when you critically analyze the provisions, you will find the provincial councils are empty shells. Now I will go to the police powers. That is in page 184. Right. So now we have eight scheduled 9 provinces. Right. Now in the 13th amendment, the 9th schedule is attached. Under the 9th schedule, list 1 is the provincial council list. I repeat again, 13th amendment. From the 13th amendment, we have come to the 9th schedule. From the 9th schedule, we have come to list 1. From the 9th schedule, we have come to list 1. List 1 is provincial council list. So when it comes to the provincial council list, a person just look at the provincial council list, may think, right, that police powers and the land powers have been vested with the provincial councils. Now we will analyze how these powers have been given, to what extent these powers have been given to the provincial councils. First, we will look at the police powers. When it comes to the police powers, many people don't understand the difference between maintenance of public order and national security. Public order comes under the police. National security comes under the tri-forces, under the Army, Navy, and the Air Forces, Armed Forces. So here it says police and the public order. Then Appendix 1. Actually, when it comes to the police powers, I repeat again, 13th Amendment. From the 13th Amendment, we have come to the 9th schedule. From the 9th schedule, we have come to list 1, provincial council list. From the provincial council list, we have to go to Appendix 1. We have to go to Appendix 1. Okay. But you need not worry too much about everything. But what I want to say is, when it comes to the 13th Amendment, we see in the provincial council list, the police powers are included. But when it comes to the police powers given to the provincial councils do not include national security. The tri-forces will not come under the provincial councils. So the first one is police powers. Then paragraph 18 is about the land powers. Paragraph 18 says about land. Land, again, it says, that is to say, the rights in or over land, land tenure, transfer, and alienation of land, land use, land settlement, and all these things are there. So a person who just look at paragraph 18 will think that the state lands are coming under the provincial councils. But we will see how it is worded in Appendix 2. So when it comes to the police powers given to the provincial councils, the police powers given to the provincial councils, we have to look at Appendix 1. When it comes to the land powers given to the provincial councils, we have to look at Appendix 2. Now we will go to Appendix 1, which deals with police powers of the provincial councils. Now we will go to Appendix 1, which deals with the police powers of the provincial councils. So when it comes to the police powers given to the provincial council, the powers do not include national security. So it is clearly mentioned at 2 places. Then when it comes to the provincial police, there will be provincial police division. Then we will go to the next one. When it comes to recruitment to the provincial police, recruitment to the provincial police will come under the Provincial Police Commission, right? Recruitment to the provincial police will come under the Provincial Police Commission. Now we will see who are the members of the Provincial Police Commission. It is very important because now many people say when the police powers are given, I told you, I said earlier also, whether the police powers should be given to the provincial councils or not, may be a debatable one. But what is not debatable is whether giving the police powers will become threat to national security or not. So now we will see. So I said the Provincial Police Commission can recruit the members of the Provincial Police Service. But when it comes to the Provincial Police Commission, there are 3 members. Who are the 3 members? The DIG of the province, a person appointed by the Public Service Commission, and the nominee of the Chief Minister. So there are 3 members of the Provincial Police Commission, which appoints the members to the Provincial Police. Now the important question is, when it comes to the 3 members, whether the majority is with the central government or the provincial government. We will look at it. So when it comes to the DIG of the province, here it says, right, when it comes to the Provincial Police Commission, I said the recruitment of the Provincial Police Service will come under the Provincial Police Commission. Not only recruitment, even transfers, promotion, transfers, promotion, and disciplinary control of the provincial police also will come under the Provincial Police Commission. But here, what is important is when it comes to the Provincial Police Commission, there are 3 members. When it comes to the 3 members, the majority of them are with the central government or the provincial government. That is the most important question here. So here it says the DIG of the province. Now we will see how the DIG of the province will be appointed. Here it says, paragraph 6 says, the IGP shall appoint a DIG for each province with the concurrence of the Chief Minister of the province. Here the word concurrence is very important. What is meant by concurrence? The word concurrence means the IGP and the Chief Minister should agree. Both of them should agree to appoint a DIG to the province. Concurrence. So that means both of them should have an agreement. But if there is no agreement between the two, if there is no agreement between the IGP and the Chief Minister, then what will happen? If there is no agreement, then the Inspector General of Police and the Chief Minister, there is no, we will assume now the IGP is going to appoint the DIG to the Northern Provincial Council, Northern Province. But the Chief Minister of the Northern Provincial Council does not agree with the IGP with regard to that appointment. So now there is a disagreement between the IGP and the Chief Minister of the province. Then what will happen? Then the matter will be referred to the National Police Commission, who, after due consultations with the Chief Minister, shall make the appointment. You see the difference between the 2 words used in this paragraph. Here, the first one is concurrence, the word concurrence. But again, the word consultation. There is a fundamental difference between the 2 words, concurrence and consultation. When it comes to the word concurrence, it is binding. But when it comes to the word consultation, it is not binding. So the 2 different words have been used with 2 different meanings. So if there is no agreement between the IGP and the Chief Minister with regard to the appointment of the DIG, then the National Police Commission will consult the Chief Minister and appoint the DIG of the province. So the word consultation is not binding the National Police Commission. Therefore, the National Police Commission can just consult the Chief Minister, but thereafter the National Police Commission can go for its own choice. Then finally, what will happen? In that situation, the DIG of the province will be a person who is with the central government. Then the second member of the Provincial Police Commission is also coming under the Public Service Commission, which is also coming under the central government. So only 1 member will be the nominee of the Chief Minister of the province. So out of the 3 members, the 2 members are with the central government. Only 1 member is with the Chief Minister. So here the national, when it comes to this composition, probably the 2 members will be the members who are acceptable to the central government, but only 1 member is appointed by the, nominated by the Chief Minister. So finally, the majority will be with the central government. Here it is about the Provincial Police Commission. Provincial Police Commission is responsible for recruitment, transfer, promotion, and disciplinary control of the people in the Provincial Police Service. Again, so then the summary is what? The Provincial Police Commission will be under the control of the central government. Again, when it comes to the arms that could be used by the provincial police, here it says the nature, type, and quantity of the firearms and ammunition or other equipment that could be used by the provincial police will be determined by the National Police Commission after consultation with the Provincial Police Commission. Here there are 2 important things. One is the word consultation. I said the word consultation is not binding. Therefore, the National Police Commission can consult the Provincial Police Commission, but thereafter the National Police Commission can decide what it wants. That is number 1. Number 2, when it comes to the Provincial Police Commission also, I explained, when it comes to the 3 members, 2 members will be with the central government. So then Provincial Police Commission also will be with the central government. So now what I want to say here is devolving the police powers to the provincial councils will not become threat to national security. Earlier, I explained when it comes to the national security is not devolved to the provincial councils. It is with the central government. So when it comes to national security, it comes under the armed forces. So the central government can send the army, navy, air force to any part of the country at any time. No need to consult the provincial government. So there's a fundamental difference between public order and national security. So the summary is devolving the police powers to the provincial councils will never become threat to national security because the president has the powers over the provincial police also. We will look at it now. So here it says the next one actually look at it very carefully. Again, the people who argue against devolving police powers to the provincial council say the provincial police will come under the chief minister of the province. Because of these wordings, DIG of the province shall be responsible to and under the control of the chief minister. So here it says that DIG will be under the control of the chief minister with regard to maintenance of public order within the province. So many people look at only this provision and argue devolving the police powers will become threat to national security. They don't look at the other paragraph, the second paragraph. What the second paragraph says: upon the declaration of emergency in the province, the president may assume such powers and responsibilities of the chief minister and the provincial administration. So that means when you look at only this paragraph, you may say the DIG of the province comes under the control of the chief minister. But in case if there is threat to national security, the DIG of the province will come under the president. The DIG of the province will come under the president. Not right. So then what I want to say is the president, if there is a threat to national security, but earlier we discussed about making proclamation under the public security ordinance. But here we are discussing about declaration of emergency. The president can declare a state of emergency. Declaration of emergency in the province, the DIG of the province will come under the president. Again, if the state of emergency is declared within a province, the IGP can send the national police to the province, and the national police will be under the IGP, and also the provincial police also will be under the central government, under the president and the IGP. But when it comes to the police powers to the provincial councils, the provincial police can use the powers with regard to the matters which are within the province, but these matters come under the national police, right? So here, look at this one. So it says, what are the subjects that will come under the national police? So that means other matters will come under the provincial police. So when you look at this list, some people will think only 11 matters are coming under the national police. All other matters come under the provincial police. But that is not correct, because look at the first one, offenses against the state. But now it is a matter to be interpreted by the Supreme Court, because when it comes to the offenses against the state, in my opinion, most of the offenses will come under the first one, because when it comes to the offenses against the state, right, it has a very broad meaning under the statutes, the legislation passed by Parliament. Therefore, most of the offenses will come under the national police. But the other things also you can look at it. But you know, when it comes to the public officers and all, offenses come under the national police, and the offenses relating to public property also will come under the national police, right? But the other matters you can look at it. But the important point is here the offenses against the state, what it means, right? So it is a matter to be decided by the, interpreted by the Supreme Court in case if the police powers are devolved to the provincial council. So I think we have a few minutes more. I will quickly look at the land powers of the provincial council. I will take another 3 minutes. Thereafter, we can go for a discussion. So when it comes to the 13th Amendment, here still the state lands are vested with the president. Only the president can alienate the state lands. But when it comes to the provincial council, but here the appendix 2 says what are the powers the provincial councils have over the state lands. But when it comes to the powers of the provincial councils over the state lands, these 3 paragraphs become very important. So when it comes to the first paragraph 1.1, it says the central government shall consult the provincial council to use the state lands which are within the provincial council. Within the province, sorry. Right. So now we will say, now the central government is going to use a state land which is within the province. So in that case, the central government will have to consult the provincial council to use the state land which is within the province. I repeat again, the central government is going to use a state land which is within a province. Then it says, in that situation, the central government will have to consult the provincial council to use the state land within the province. But again, here the word consult is very important. The word consult is not binding. So that means the government can just discuss with the provincial council, then the government can decide anything that it wants, because the word consult is non-binding. It's non-binding. There is no need to have an agreement or concurrence between the central government and the provincial government. So the summary is the central government can use any state land for its purposes. Here the central government will have to consult the provincial government, but the word consult is not binding. Therefore, finally, the central government will decide what it wants. Paragraph 1.2. Here it says, government shall make available to every provincial council state land within the province required by the provincial council. This is very, very important, because with 1.2 clearly says that the state lands are with the central government. And when it comes to the 13th Amendment, the state lands are with the central government. Now, President Ranil Wickremesinghe very often says, or some people say, the 13th Amendment will be fully implemented and the land powers also will be given to the provincial councils. But my question is, how the president can devolve the land powers to the provincial councils which are not in the 13th Amendment? Because look at this 1.2. It says, government shall make available to every provincial council the state land within the province. When it comes to the provincial government, if it wants to use a state land, then it will have to depend on the central government, right? The central government will have to give the state land to the provincial council to use the state land for its purposes, right? Look at it. Government shall make available to every provincial council a state land within the province. So we will assume when it comes to the Northern Provincial Council, it wants to use a state land. The particular state land is within the Northern Province. But here, the Northern Provincial Council will have to get the land from the central government. If the central government does not give the state land, then the Provincial Council can't do anything beyond that, because the government will have to give the state land to the Provincial Council will have to give the state land to the provincial council to be used for its own purposes, right? So here again, if the central government decides not to give the state land to the provincial council, then the provincial council can't do anything beyond that as it is now. Then the third one, alienation of state land within the province is with the president. Is with the president, but only the president can alienate the state lands. Then when it comes to these provisions, and right, these provisions were analyzed by the Supreme Court in Solamuthu Rasu case. In the Solamuthu Rasu case, the Supreme Court decided, after analyzing the provisions in the 13th Amendment and also in Appendix 2, that the state lands are with the central government, but the provincial councils can only use the state lands given by the central governments. So the provincial councils can use, control, or administer the state lands given by the central government. So that means after the Solamuthu Rasu case, the state lands are with the central government, but the provincial councils can use only the state lands that have been given to the provincial councils, but the provincial councils will not have the ownership over the state lands which have been given to the provincial councils, but the provincial councils can use those state lands. So very limited powers. But what is important is here national policy. The government of Sri Lanka shall establish a national land commission which would be responsible for the formulation of national policy. But still the commission has not been established. Therefore, there is no policy. If there's a national land commission, and if there's a policy, at least the policy may have some provisions with regard to the powers relating to state lands. But now, as it is now, there is no such commission, there is no such policy. So the summary is, after the Solamuthu Rasu case, the decision given by the Supreme Court, the state lands are with the central government, the provincial government can use only the state land given by the central government. So that is why I asked, after the Supreme Court decision, how the government can devolve their state lands to the provincial councils, which are not in the 13th Amendment now. So the summary is now, I think now the time is up. The summary is now, basically, in my opinion, the powers have to be devolved. As I said earlier, the powers have to be devolved at provincial level, right? Because the problem is actually when it comes to the Tamils, they demand the federal system of governance, but the federal system of governance was demanded firstly by the Canadians. They made a presentation before the Colombo Commission, and they demanded the federal system of governance. Thereafter, SWRD Bandaranaike in 1920s has written many articles. In those articles, and also he went to Jaffna and spoke at the meetings convened by the Congress, Youth Congress in Jaffna, that the federal system is suitable to this country. But when it comes to federal system of governance, it is also a system of governance which is in practice in many countries, more than Sri Lanka also, including Belgium and Switzerland. But the reality is now Sri Lanka, the reality is now we can't think of federal system of governance in this country. Now, what I want is the 13th Amendment, which is already is in the Constitution, which is part of the Constitution, should be fully implemented. If the 13th Amendment is not fully implemented, the President and the government violates the Constitution by its inaction. The constitutional provisions could be violated by action or inaction. So since the 13th Amendment is part of the Constitution, now we talk about 13th Amendment. Actually, I would say we need not talk about 13th Amendment. We talk about Constitution. It is part of the Constitution now. So if the provisions of the Constitution are not implemented, then it becomes violation of the Constitution. by inaction. So finally, I would say I am for the empowerment of the provincial councils, and in my opinion, the 13th amendment should be amended, because the later, if you have time, one day we look at it. If you have time, you look at the Provincial Councils Act number 42 of 1987. When you look at the Provincial Councils Act number 42 of 1987, there you will find a chapter about the provincial public service. When it comes to the provincial public service, the governor appoints the chairman and the members of the provincial public service, and the appointment, transfer, promotion, and disciplinary control of the members of the provincial public service also come under the governor. When it comes to the national public service, after the 21st amendment, does not come under those powers are not coming under the president after the 21st amendment. But when it comes to the provincial public service, the governor has the full powers, but the governor can delegate the powers to the Provincial Public Service Commission, which is appointed by the governor again. So in my opinion, the governor should be a ceremonial governor. But here what happens is, the president, according to the 13th amendment, the scheme of the 13th amendment, the president can appoint the governor and control the provincial councils through the governor. But in my opinion, the governor should be a ceremonial governor. So when it comes to the other matters, I have already explained. But when it comes to the land powers, definitely the provincial council should have the land powers to make use of the state lands for the subject matters devolved to the provincial councils. Police powers, you can argue whether it should be devolved or not, but even if it is devolved, it will never become a threat to national security, because I have explained about proclamation of proclamation under the Public Security Ordinance, and also I have explained about the declaration of state of emergency, and also I have explained the national security comes under the armed forces, which comes under the central government. So with that, I would like to conclude my presentation, but I strongly support for the empowerment of the provincial councils for two reasons. One is for the reconciliation of the ethnic conflict, and the other one is for the development of the country. When it comes to this country, we have to develop the country at provincial levels. So when it comes to the provinces, if I take the northern province, there are many resources. If the provincial council has the powers, the provincial council has the powers to make use of the resources and develop the province, then the development of the province will contribute to the development of the country. Now, in my opinion, if you go for that type of development at provincial level, then the provincial governments can generate its funds, and then from the provincial governments, the funds could be transferred to the central government. To develop this country, in my opinion, I think we have to give more powers to the provincial councils. So finally, I am strongly supporting the implementation of the 13th amendment and empowerment of the provincial councils, and also I would say that the provincial council system is important for the reconciliation of the ethnic conflict and also for the development of the country. Finally, earlier at the introduction, it has been mentioned that I was in the previous committee appointed by the former president. But when it comes to that committee, yes, I was there, but it does not mean I have agreed with what they wanted. So when it comes to my position, my disagreement started with Article 2 of the Constitution, because the Article 2 of the Constitution provides Sri Lanka is a unitary state. So I disagreed with that in that committee. So my argument was, when it comes to the structure of the country, don't say unitary state, don't say federal state, you just say Socialist Republic of Sri Lanka. Keep it open, right? So that was the first argument. The rest also, there were many disagreements, right? I think I have already taken little more time. So with that, I would like to conclude my presentation. Now I think the time for the questions, I think. Thank you.
Yes, sir. Thank you for the wonderful presentation and thought-provoking, logical argument. I would say so. Sir basically covered, all aspect and the futures of the 13th Amendment. So we could say, in summary, the prime objective of the 13th Amendment was to establish a regime for devolution of powers. So within the units of devolutions, according to the language of the 13th Amendment, we could say provinces. So within that structure. So, but when considering the substance of the 13th Amendment, it is controversial, as Professor said, whether it has provided meaningful devolution and autonomy to devolve the unit, the provinces, because the 13th Amendment itself contains some provisions which hinder such meaningful devolution of powers. So it could be the restriction or consultation or concurrent powers, like that. So the central government continues to be legally supreme over legislative and sometimes executive powers that have been devolved to these provinces. So, and I also wanted to add at the same time, when we consider, as the professors, according to professor's argument and the presentation, the 13th Amendment has provided, in some extent, the rooms for the substantial devolution of powers by establishing legislative, executive, and administrative autonomy within the given, sphere of powers. But if implemented successfully, and also parallelly, Professor suggests several, amendments that are necessarily to be included. So those are, within the hands of the in the parliament and other, executive of the country. So we now there are several consultation and the argument and the thought-provoking, developments we can see. So it all depends on the future. So let's see. So what will happen in the future regarding this? So those are very, actually thought-provoking and very interesting features, I might say. So then with that note, I kindly open the floor for the question and answer. So as I already mentioned, at the ground rule, we'll, we can, you can raise your hands and unmute yourself and pose your question. And otherwise, if not, you can, send the question directly to us, to the chat box. We can, read out the question and, we can consider, we can give some answer. We try to give some answer. And so your questions, should be relevant to the topic, that is the ground rule to the webinar. So I open the, for the audience to raise your clarification and the question, please. Shamila madam, we experiencing breaking in your voice.
How about now?
Still, madam, I think there's an echo or something.
I will
Noise.
pose the question to you and
Yes, madam. Yeah, that's perfect. Yeah. And before that, sir, I received a question. So
Oh, yeah.
some audience, some invitees have posed a question. So there is a conception that these 13 amendment sometimes in practically would be there are some arguments would be danger for the unitary state, unitary practice, unitary state principle. So what do you think, Professor? So what do your thoughts on that? So,
Definitely not, because it was analyzed in the case decided by the Supreme Court with regard to the 13th Amendment. Because if it becomes danger to the unitary character of the state, then when the 13th Amendment was challenged in the Supreme Court at that time, the Supreme Court might have decided that the 13th Amendment cannot be passed without referendum. Because when it comes to any amendment to the Constitution, which violates or which conflicts with Article 2 of the Constitution, which is about the unitary character of the state, then that particular amendment cannot be passed. That cannot be passed without referendum. That cannot be passed without referendum. So therefore, when it comes to the question here, I would say definitely it will not become threat to the unitary character of the state, because in my opinion, now the communities are divided in this country based on ethnic identity. But if we want to promote the Sri Lankan identity, it becomes important to reconcile the conflicts and promote the Sri Lankan identity. I would say the devolution of powers will bring the Tamil community and also promote the national identity among the Tamil community, of course, the Muslim community, right, with the Sri Lankan identity. But now the communities are divided based on various conflicts in this country. Also, the provincial council system has been accepted by the people in the south also. But now only the provincial councils are not functioning. But before that, when it comes to the 9 provinces, all the major parties in Sri Lanka contested and they all participated in the provincial government. So the provincial council system is already in the governance system of this country. But now the main question is, one is again having the election for the provincial councils and also giving more powers to the provincial councils. That means the powers that are already in the 13th Amendment. When it comes to the question about unitary state, I will simply say the provincial councils are under the control of the central government and also under the control of the governor of the province, who is appointed by the president, and also under the president. There is no threat at all when it comes to the national security of the country or the unitary character of the state.
Yes, sir. Thank you for that clarification. And in addition to, I want to make a few points in addition to that. And so during the code, when the code determined the 13th Amendment, also they have the majority has decided that there is no threat to to the unitary character of the state. So then that's why the Supreme Court proceeded to enact the 13th Amendment without a referendum, if I'm not wrong. Is that, sir?
Yes, that's right.
Yeah.
Now, actually, now the people who say that the full implementation of the 13th Amendment will become a threat to the unitary character or the national security will have to explain clearly on what basis they make the argument. Because many of them make those arguments without knowing what I have explained now. I have clearly explained about the powers of the president after making the proclamation under the public security ordinance and after the declaration of state of emergency. So many people, without looking at those provisions, they look at some provisions and make those arguments. But I think there is no threat at all when it comes to full implementation of the 13th Amendment.
Thank you, sir. Thank you very much. And there are two other questions in the chat box. I can see one question states, are there any disadvantages to implementing the 13th Amendment, particularly from minorities' perspective?
There is no disadvantage, but when it comes to the provincial council system as it is under the 13th Amendment, the powers are not adequate. That is my point. Actually, we had to give more powers to the provincial councils, but that is not possible under the 13th Amendment. If we want to give more powers to the provincial councils and empower the provincial councils, then we have to go for another amendment, but that is also not possible in today's context. But when it comes to full implementation of the 13th Amendment, there is no disadvantage at all to the minority communities. But of course, when it comes to the merger of the two provinces, may be an issue, because when it comes to the Eastern province, we have the three communities at equal percentage. 1/3 Sinhalese, 1/3 Muslims, 1/3 Tamils. So the question will be whether the people in the East will agree for the merger of the two provinces. That is a political issue, political decision. But when it comes to implementation of the 13th Amendment, I would say, other than the issue related to merger, there is no other issue at all. There is no disadvantage. And also the minority communities also will take part in the governance in this country. So I would say it is very, very important, because when it comes to this provincial council system, it is important for the development of the country. And also when it comes to the politicians also, all politicians can't go to parliament. So there are many politicians who can serve to the people by becoming members in the provincial council. So the provincial council system will give an opportunity to them also. For various reasons, the implementation of the 13th Amendment becomes very, very important.
Yes, sir. Thank you. And there's another question posed by from an audience. So according to the Solemuturasu case judgment, it was decided that the provincial council had no jurisdiction on the state land. Provincial council court has no jurisdiction to entertain such an application under the Article 154p or B of the Constitution. So, can such application can be made before or institute before the district court? So, is there any possibility within the province? So, one question posed.
Right. Shall I make my comment?
Yes, sir, please.
When it comes to the Solemuturasu case, actually we have to look at the background of the case. So that case was with regard to ejectment of a person from a state land, from a land, right? The
Yes.
particular Solemuturasu case was relating to ejectment of a person from a land. So there was a fundamental question whether the particular land which he occupied was a state land or not. That is one question. Another question, when it comes to that case, the Supreme Court has gone to the extensive analysis of the provisions of the 13th Amendment. There, I don't think there was any representation from the people who support the provincial council system, because the particular issue was about ejectment of a particular person from a land. Therefore, when it comes to that case, people who support the provincial council system have not become parties and argue in favor of devolving more powers to the provincial councils. But in my opinion also, to some extent, I agree with the reasons given by the Supreme Court. When we look at the wordings in the appendix 1.2, appendix 2, 1.2, right? Again, I repeat, appendix 2, 1.2, it gives the impression that the state lands are not with the central government. The provincial government can use only the lands given by the central government for its use. That means the state lands are with the central government, but the provincial government can use only the lands that have been given by the central government for the use of the provincial government. But again, the provincial government will not have the ownership over the state land. But only thing now, I would say, under the existing 13th Amendment, what we have to do is, now the present government can establish a National Land Commission and make a national policy to resolve these matters with regard to sharing the state lands between the central government and the provincial government. But I would say when it comes to the national policy, they have to focus on giving the meaningful effect to the 13th Amendment. Otherwise, what will happen is, again, the 13th Amendment will not be fully implemented and the provincial council system will be ineffective and will become, as some people call, white elephant. The people who call it white elephant made the provincial council system to become white elephant. Because the problem is, when it comes to the 13th Amendment, the governments did not have the political will to implement effectively the 13th Amendment and have the provincial council system as an effective system in the country. So that is the problem. There's no political will. That is the main issue.
Yes, yeah. Thank you for that, for the response. And there are a couple of questions, interesting questions. I have already copied those questions to everyone. So one question reads, so what are the main obstacles in implementing the 13th Amendment? So in the, yes, sir.
Right. The one obstacle, I would say, the people in the South, I would say that most of the people have understood what is in the 13th Amendment. So misinterpretations are given to the people and the people believe that, right? So the many politicians, right, misinterpret the 13th Amendment and give the impression to the people in the South that full implementation of the 13th Amendment will divide the country. And also, when it comes to the Mahanayakas also, they have opposed the full implementation of the 13th Amendment. But I respect the Mahanayakas and I follow Buddhism, but I would say when it comes to the religious leaders, the religious leaders are the best people who advise on matters related to religion. But when it comes to these matters, the people who have expert knowledge will have to make the decision. When it comes to this issue, the experts will have to educate the people about the importance of the 13th Amendment, and also they have to alleviate the fear in the minds of the people in the South. So the people in the South, most of the people don't know what is in the 13th Amendment and they have the unnecessary fear. And also, when it comes to this country, always the political parties make use of these issues for their political achievements. When President Ranil Wickremesinghe made the announcement for the full implementation of the 13th Amendment. Most of the major political parties are silent or not making any statement with regard to their positions in implementing the 13th Amendment. So what I want to say is here, if the major political parties come together and take a position, then it could be simply implemented. But I have a serious doubt whether that will happen or not, because since the independence of this country, the political parties make use of these matters for their political agendas. So when it comes to the Sri Lankan politics, always the Sri Lankan politics has developed based on the ethnic conflict, war, and peace, not based on development. So when it comes to Sri Lanka, the political parties are not promoting very much the development politics. Therefore, here when it comes to the question here, if the parties, major parties at least, come together, it could be simply implemented. But I have a serious doubt whether major parties will come together, because they will make use of this also for their political advantages.
Thank you, sir. Thank you very much. And I think, so as you elaborated, and there's the other connected question also posed, who is actually responsible for not implementing the constitutional provision in the 13th Amendment? So actually, sir has responded and covered those aspects as well, because we basically we are the responsible persons are acting in a narrow, they are thinking in a narrowly and without knowing the features and the ambitions of the 13th Amendment. They are started to argue. So that is the main obstacle, as Professor correctly pointed out. So this is that's why we say these kind of awareness and reading and writing on the 13 amendment are very vital, very important in the present context. So those are very important, and those are for the all as being the people, ordinary people in the country, as being the academics, as being the students, as being the learners, as being the ordinary citizens of the country. We are responsible to to understand what is the real the goal and the features of the 13 amendments, as correctly pointed out. So those are very interesting and enthusiastic response and the question from the audience. So we can, I think we can have one or two questions, and so any question? So we are also about to reach almost passing the time also. So I think you all raised some vital, interesting question, and we hope so. Right. So if though so then I'll now we'll proceed to other items of the today's agenda, to the webinar. So I'll now be before concluding the these webinar, I formally and cordially invite Dr. Ali Ahlam to deliver the concluding remarks. Actually, Dr. Ali Ahlam is our one of the board member of the RPSL Consortium, and he is the chairperson of the Youth Empowerment Sectoral Committee of the RPSL. So then I welcome you, sir, to conclude the session with your vote of thanks. Over to you.
Thank you, Kamal. Am I audible?
Yes, yeah,
Yes.
we can.
Thank you. So, good evening. In fact, today's speaker, Professor A. Sarveswaran, faculty of Law, Colombo University, and distinguished participant, thank you very much for participating today's event through RPSL. In fact, I am honored to thank our speaker today, Professor A. Saravanan, and for sharing his in-depth knowledge in this forum. Is one of the subject, it is basically on the reflection of the 13th Amendment to the Constitution. I'm sure this session has been benefited us in terms of awareness of this, to get the true goal of it. A lot to discuss this due to time frame, and I think we couldn't go more on that, and there would be more questions, and it's getting really interesting to get to more about it. Anyway, it was a wonderful session, sir, and it's really insightful, and we should continue this kind of a program in the future too. And once again, thank you for Professor A. Saravanan for your contribution and your wonderful session. And also, I would like to thank our moderators today, Mr. Kamal Ahmad and Ms. Munawara, and also our Dr. Shamila for organizing this wonderful session today as well. So I wish you all the very best, and thank you, Dr. Shamila. And we look forward to more events like this in future. And RPSL continue to guide, educate, and empower youth to develop a future leaders to emerge. And we don't forget that, and we always give this kind of a programs and events in future for everyone in any platform to emerging and supporting all new leaders coming into the society. So with that note, I would like to conclude my quick thanking note, and may Almighty God bless everyone. Thank you and good evening.
Thank you so much.
Thank you. Thank you. Thank you, Professor. Thank you very much.
Thank you.
Thank you. Thank you all.
Thank you for the opportunity.
Yes, sir. We are delighted to have you, sir. Thank you. Thank you all. Good night.
Good night. Good night.
Okay, thank you. Dear